So I said this morning, once you establish liability, there are two possible responses. One is to license and the other one is to filter. And filtering has been the most controversial end of the directive. So in many ways, it's appropriate that we've got a very numerous panel to deal with this. As in the morning, I think it makes sense probably if you introduce yourself very briefly with your role, what you do, then it's clearer for the audience where you're coming from. So, Giancarlo, do you want to just say very briefly what your role is?
Good afternoon, everybody. My name is Giancarlo Frosio. I'm an associate professor at the CEPI, the Center for International Intellectual Property Studies at Strasbourg University.
Okay.
Hi, this is Miquel Peguera. I'm an associate professor at Open University of Catalunya in Barcelona.
Alessandro?
This one. Hi everybody, I'm Alessandro La Rosa. I'm Italian. I'm a legal advisor for Mediaset, the Italian broadcasting group, and which is also an ACT member.
Good afternoon, everybody. My name is Maja Stoyanova. I'm Senior Legal Advisor at SiteGround. This is a web hosting company based in Sofia. Nice to meet you all.
Mathilde?
Yeah. Hi, my name is Mathilde Renou. I'm a legal consultant and I'm the representative for the International Association of Scientific, Technical and Medical Publishers. So you can say STM, that's way shorter.
Excellent. Okay, so we go through our 5-minute presentations, statements, which we don't interrupt, and then I'll pose a number of questions. Okay, Giancarlo.
Okay, thank you very much. Thank you, Martin and Martin, for having me. This is really what people spending the last few years looking into the directive are we're waiting for. I mean, they to talk just about the Article 17. So I'll try to be a good guy and follow the questions that were asked to me. So I will tell you something about the nature, status of these preventative duties, been asked copyright infringement or a type of liability. Now I'll tell you something about the relationship with Article 15, and I will finally mention briefly something about transparency. So I think we already have some sort of an agreement here. We agreed on the fact that the copyright, the exclusive right is still the same communication to the public on the side of the, obviously, of the right holders. We have done an extension of this communication to the public to OCSP, which now are primarily liable for that, rather than how until a certain point just a secondary liable for infringement. So we probably reached already an agreement. I counted at least 3 scholars mentioning that, Jansen, Quintes, and Nordeman, that we have some sort of hybrid sui generis right, lex specialis, most probably, and so I give account of that, of that agreement, and I think that that's the direction in which we are going. Now, it's going to be a lex specialis because now we are going to have, thinking about this new preventative duties and the liability side of the communication to the public right, we have less limitation to primary liability of OC, SSP, X, the InfoSoc directive as interpreted by the CGU. Because we need to make clear that the CGU already introduced some primary liability for some selected platforms. It did that with its jurisprudence on communication to the public and linking. It did that in Zigo and Williams. And there it went beyond the strict liability copyright traditional approach, including a number of several tort or negligence-based conditions. It already included and introduced knowledge condition. It did that, it related that in GS Media, the knowledge to the for-profit activity, and we see this reflected in the new norm. But Zigo and Williams, they never reached so far as the new Article 17 because they provided a couple of additional requirements, at least as I read it. One was inducement, and the second one was substantial infringing uses. So therefore, we have obviously a move forward in terms of extension of the reach of the right in this new Article 17. obviously, then we have a limitation, an expansion of the liability that was provided under Article 14 of the ECD. We still have the exemption from liability for all platforms, including obviously those that are excluded from the definition of OCSSP. But the OCSSP also have to stay down what is noticed, and also have to filter ex ante what is noticed, let's say. We're going to see how then it's going to be noticed, but it's some information given there so that notice. And then make best efforts to license. Now, on a slightly different side, trying always to think about what is the consequence of a violation of the preventative duties. I think here there might have been a question, is that the preventative duty any type of negligence-based new liability for not ensuring the unavailability of specific works as they are noticed? So, giving an example, let's say that an OSCSP let available a work whose use is covered by privileged use for which necessary information has been provided. Could we think about some sort of liability, which is not copyright liability, but negligence-based for letting something available which is not? I would exclude that option. I mean, if this was maybe the question that was posed in thinking about the status of the right, I would exclude that because the norm refers specifically to liability as for unauthorized acts of communication. So I don't think that the norm is creating any type of a new right, sui generis right for the availability of work for breaching an obligation and through negligence of letting available works which might have been noticed by the right holders. Then the second question is the one about prohibition, about general monitoring obligation and Article 15 ACD. So here there is no disapplication of Article 15. We used to have one in 2016, but then was out. But my point here is that I don't think there is a general monitoring obligation in place. We used to have one in the pre-July 2017 text, but then how the workaround has been built, this is not happening anymore. We distinguish 4 categories of monitoring: general monitoring obligation, voluntary general monitoring, specific monitoring obligation, and voluntary specific monitoring. Obviously here, how the norm is built and created, we are going to have a voluntary general monitoring. And as you realize, only the general monitoring obligation would be covered by Article 15, but it's completely lawful to have any type of voluntary general monitoring. Now, and I try to get through this a little bit faster. Now, Article 1710 basically provided that stakeholders are under the obligation of coming up with a code of conduct, in my view, which will be crystallized through guidance issued by the Commission. So we are going back again to a traditional tool now deployed by the Commission, that are voluntary measures here. If they find a way to do this without monitoring, it's good. But in any event, if they do not find a way, as they cannot, so de facto we have a monitoring obligation, but ex lege we don't have a monitoring obligation where we have a voluntary monitoring scheme in place, that will put together that on a voluntary basis. So this is also in terms of, are we going to have a challenge before the CGU, what's going to happen? My view is that if there's going to be such challenge, that's going to be the answer. Might be a de facto monitoring obligation, but ex lege is not. It's just a voluntary monitoring scheme, general monitoring scheme. This is just very much take it, boom, it's my opinion. Last, let me just mention briefly transparency. Now, here the big issue, I think, is, okay, transparency, we're going to have the transparency report. They're going to tell us how monitoring is happening. But I think the issue is algorithmic transparency, and especially algorithmic accountability. So the problem with opaque algorithms, and here we have a number of open issues: accountable to whom the algorithms should be, and accountable for what they should be. I think one of the basic answers is accountable to users, at least. through transparent search. So when this Article 10 is going to happen, it's going to make multi-stakeholder discussion. We should try to have a transparent source code. Trade secrets, though, is a problem here. But users should be also enabled to understand what the algorithm is actually doing. And here we're going to have plenty of technical, organizational, and regulatory challenges in ensuring the access to the data. There's some proposal from Nival, Kincoren, and Perel about thinkering, using thinkering, so as a solution to black box moderation through grassroots oversight, through which people systematically test and record how to intermediately respond to representative, like real content submitted to the platform. Then on top of that, and I conclude, we probably looking for a proposal in which adherence to algorithmic accountability would lower liability of intermediaries. And this could contribute to effectively protect better fundamental rights. Actually, the Council of Europe and Beth Wagner in particular have come up with specific provision for ensuring this algorithmic accountability, which might include
Giancarlo, I think we have to.
I'm done. Transparency of automated decision, external auditing of the algorithmic accountability mechanism, independent external body addressing complaints, radical transparency of the system, irrevocable storage of the decision, user-friendly explanation of the automated decision, and availability of human review of the decision. A lot of stuff I threw in. Let's see if we can then chat about it later on. Thank you.
Okay, thank you very much. Okay.
Okay.
The challenge is to
Yeah, to stick to the 5 minutes, I will try to do that. So very quickly, the directive tries to address this idea of the so-called value gap, and there were two elements to be addressed, since they would seem the obstacles to get to solve this question. One is, are those platforms, I will refer to those platforms to avoid all the acronym, performing an act of communication to the public. This isn't clear before the directive. And then, are they protected by the e-commerce safe harbor? They say yes, so that would be considered another obstacle for this value gap question. Well, so the directive essentially says, well, they, now I state that they actually perform an act of communication to the public, and in addition, I would expel them from the safe harbor. And then there is an explicit attribution of liability if they are communicating this unauthorized stuff. The mere fact of characterizing this action as a communication to the public does not mean that they would necessarily fall outside of the safe harbor. And that's because the safe harbor was never meant to depend on how the source of liability was characterized. So it actually covers both direct and indirect liability as long as the conditions are met. And second, because the fact of being considered a primary infringement doesn't mean necessarily that you are not neutral enough to be covered by the safe harbor. And the very DSM directive acknowledges, recognizes that when saying that this platform may still be protected by the e-commerce directive safe harbor for other kind of liabilities. So that that acknowledges that it may be neutral enough to be covered by it. So still the directive says, since in recital 66, since it is not the platform itself who has uploaded the content but their users, there is a need for a protection from liability, which is the same rationale that in the e-commerce directive. But then it crafts a new safe harbor, which has a completely different premises than the one of the e-commerce directive. Specifically, unlike the hosting safe harbor, here in 17.4, you are necessarily liable if you don't fulfill the conditions of the safe harbor, which is completely different than in the e-commerce directive, where there is no assumption of liability in the first place. Second, you need to monitor here completely different situation than in the e-commerce directive. That's true only with regards to the files for which right holders have provided the platform with sufficient information. And unlike the e-commerce directive, you have to keep the content down. So there is a stay down obligation, which is not established in the e-commerce directive. Again, as I interpret this 17.4c, only where sufficient information has been provided. And that's, to me, that's the reason of the reference to be in this article. And I agree with Giancarlo, this is direct liability. It's not a new kind of liability for failing to fulfill these conditions. Is this general monitoring in the sense of Article 15 of the directive? To me, it is. According to the construction of the Court of Justice, for instance, in Sabamnet log, it's clearly an identification of the works represented by a particular right holder or CMO. And let's see what the court says now in the Facebook case, but still I think that it would clearly fall under Article 15. Does it matter? Since, in fact, the DSM directive has expelled these platforms from the safe harbor. So from Article 14, and Article 15 is linked to Article 14, I think, yes, that still matters because the effect of Article 17.3 is only for the purposes of the limitation of liability, and so it may arguably still, Article 15 might still apply, and there are other foundations or other rationales in addition for prohibiting general monitoring obligations that are essentially data protection and freedom of expression. Surely we'll have time to debate on these issues, but I'm stopping here.
Yeah. Well, thank you very much. So we move on to Alessandro and
Yes, I'm going to be very, very quick. What I would like to say is that by reading Article 17, paragraph 4, it seems like the letter B and C innovate to some extent compared to the past. But I'm not so sure about that because actually preventive duties were already provided in the e-commerce directive, and recital 40 and recital 48 explicitly provided a precise duty of care to all providers. So if you read the Court of Justice case law, actually in the L'Oreal case and in the recent opinion of the Advocate General in case C-18, 2018, against Facebook, it is quite clear that Article 15 of the e-commerce directive does not prevent providers already. And we are talking about hosting providers, which definitely are very different providers compared to the sharing providers, of a specific obligation of duty of care. So they do not have a general obligation of monitoring obligation, but they have a specific obligation of monitoring on specific case. This is what it was said by the Advocate General in the L'Oreal case, and on a specific topic of intellectual property. And this is what, again, the Advocate General says on the Facebook case. So a hosting provider, as Facebook has been qualified, has a specific obligation of monitoring not only identical information, but even equivalent information as far as they come from the same user. So if you read this, compared to letter C of paragraph 4, of Article 17, I would actually say that the e-commerce directive provide for even a higher level of duty of care for hosting provider compared to the ones provided in letter C, which is quite funny because hosting providers, at least at the beginning of the when the directive was emanated, of course, they were not for sure providers who use the content uploaded by user in order to make money, but they were meant just to host and storage content, which is very different from the video sharing platforms. That's in order to say, how do we have to interpret the best effort of preventive duties provided in Article 17, Recital 4? I would say in a higher way compared to the one that we expect from hosting provider, for sure. Because don't forget that video sharing platforms are making money out of content uploaded by third parties. And so just to give you an example of how the Italian case law has interpreted the e-commerce directive, we have a very recent case, which is the case of Mediaset, which I was representing in court against the Yahoo video services, which is a service that was going on in 2011, which is not on anymore. And the Court of Justice said, the Supreme Court, the Supreme Italian Court said that even if we want to interpret the Yahoo service as an hosting with a passive role, they still have to respect this specific obligation of duty of care. And this come out from the e-commerce directive, not from the new one, of course, the DCM directive. And the Supreme Court said that Yahoo was entitled not only to remove the specific content that were indicated by the right holders, but there is a stay-down obligation which cover all those content of the same nature. So the problem and the question is, how do we have to interpret the concept of same nature? And this is one of the questions, I think, that we will have to face also in the interpreting the concept of best effort provided in letter B of paragraph 4 of Article 17. Thank you.
Okay, so now we're moving on to Maya.
Good afternoon, everyone, and thank you very much for the invitation. It's a pleasure to be here. I will focus more on the point of representing a web hosting company, and I will focus on Article 15 and Article 7.4b. To start with, I will share my own experience, and I will share that until now we are following the rules in Article 15 of the directive, and as soon as we are aware that there is infringement and there is a notice and takedown procedure, we are taking expeditious measures in order to be sure that we are complying with all legislation. Now, when I'm reading Article 7.4b, I think that in my personal opinion, we need to take measures which need to be higher than before, because when I'm reading the text, I'm not sure what exactly the definitions are. And in my perception, even though in point 8 is stating that there is no obligation of general monitoring, we should have some, even though we are not sure that we are in the scope of this directive. But in my personal opinion, what we did so far and the internal procedures which implemented in the company are not enough anymore, and as a hosting provider, all the hosting providers need to take more measures, even though it's very difficult and challenging, because I have to say that on a daily basis we are acting like a judge, and we need to take a decision to stop that access or not. And many times when we stop an access to a different website, afterwards we have, for example, a right holder who is saying why you stopped the access. So it's really complex for the web hosting providers. And sometimes it's also complex because you're not sure if you violate, for example, one of the fundamental principles of freedom of speech. And this is the reason why, in my opinion, filtering, it's one of the decisions which maybe will comply with the requirements stated here, but at the same time it's challenging because it's cost efficient. There is not 100% certainty that always the filter will detect a copyright protected content. So I have to say it's very challenging, and we all need to think about the best measures which we need to take in order to be sure that we are complying with the legislation. So thank you very much for your attention.
I come back to you straight away, if I may. Can you tell us a little bit about the technology you employ? So you say you introduce new measures.
For the time being, we are stick to the internal policies like repeat infringer policy, and as I stated before, whenever we are aware that there is infringement, we act expeditiously. But when we find out how, first of all, the directive will be transported in the national legislation, maybe we will think about filtering, because we need to be sure that we are complying with everything. But at the moment, as we discussed earlier, we still don't know if we need to comply with the directive or not. So it's really challenging. But if we need to comply, of course, we will think for different measures like fingerprinting or filtering.
Okay, thank you. Very
You're welcome. Thank you.
Okay. Now we move on to the citizen publishers.
Yes, thank you. Well, actually, I'm going to address a question that is also relevant for you when you say that this is cost efficient and you're not 100% sure to remove the content of a right holder. So I'm representing the scientific publishers, and today I'm going to focus on the question of what is relevant and necessary information under Article 17 for B and how this trigger liability. And specifically, I'm going to present you a small subsector of right holders and how this small subsector of right holders, so the STM publisher, is going to be impacted by Article 17. And for us, we could resume that in that way. This is how the paradigms change for platform liability to platform responsibility. So let me just give you a few words on STM publishers. So STM publishers is a really small subset of all publishers that you know, like music publisher, press publisher, book publishers. And despite our name, which says that we cover scientific, technical, and medical publishers, STM publishers are in fact cover all hard and soft sciences, so including humanities. For STM publishing, the availability, digital access and availability is a reality already since more than 20 years. Everything is fully digital to a point that in-print content is actually really fastly decreasing in these few years. And because STM is fully digital, the issue of illegal copyrighted content available on some platform was already addressed previously, mostly on voluntary basis with platforms and other stakeholders. It's important to say that STM publishers also continue to innovate, to have tools for that purpose. We are currently interacting with about 40 different platforms, which are some of them owned by STM publisher and some of them are not. What I mean by that is, for example, we're interacting with platforms such as ResearchGate or academia.edu. But for the moment being, it's maybe good to say that YouTube is, for the moment, not our primary concern when it comes to the uploading of illegal copyrighted content in our field. Where do we fit in Article 17 then, you may say? So, well, Article 17, we fit exactly in Article 17.4. And it's important to recall that indeed the first condition is important, meaning that there still need to have best effort for licensing before we can go to the second part of Article 17. So relevant information and necessary information. For STM publishers, there are different ways we can do that. So what's important to say is, like, of course, the burden remains on the platforms according to the new Article 17, but we already have tools in place and technology in place to address the relevant information we need to supply in order to trigger liability. So just a few examples, because then it gives a more practical view of what exists already. For example, platform can use a pinging system, which is going through an API, basically, and then test the database of the publisher with the content that has been uploaded previously on the platform, and then with the ping system, which is like a real-time system, it would know whether or not the content is compliant. Another probably most obvious thing is to have a meta tag in place in the content so that the platforms know whether the content is indeed compliant or not. But aside of technological tools, we also have voluntary principle into place, because in our case, in platforms where we are dealing with, there is often an issue of for authors to know whether they can share their content or not. So STM Publishers has been committed for a long time now to have voluntary principle for authors and know what they can share, how they can share, where they can share. So if you are interested, I can give you the names, or I can share it.com. This is it. So just to finish, because I think we are running a bit. What's important to recall is, like, yes, there is a shift in liability toward the platform, and yes, this is new, and there is a new burden for platform, and we cannot take totally the burden of platforms, but we already in collaborative, and we already have tools to help for that. And to answer the question whether or not this would lead to general monitoring, we think that not, because the fact of these tools that are available for use for platforms is a wish to do so and are very, very specific to the content. Thank you for your attention.
May I follow up straight away on, so you offer access to a database through an API, and that access is available to your partners at the moment, or to everybody. So is it the 40 platforms you have arrangements with, or is it basically an open API which anybody can access?
So far, it is with the 40 platforms we have access with, but obviously it could be open to all the platforms that would be in the situation of sharing scientific content. Also, these tools, some are in place, but some are in development, and they will need to be adapted as well to the new framework of Article 17.
May I ask the same question of Cedric? So the question is with the API which offers access to the database of rights, whether that is open or just privileged to partner organizations. So how does Google handle that? So if a right holder and the platform is connected to an API, should I take a mic? Yeah, that way I think really be helpful.
Well, so first,
so it doesn't work. So
yes, the answer to the question depends on first our business decision to do this or not. So, and if we want to go to the filtering route or when using some kind of API, in general, our main requirement is to make sure that we have access to something that's comprehensive, reliable, and up to date. So that's without this, if we don't have information that is comprehensive, reliable, and up to date, it's impossible for us to ingest that. So there's a question of quality first. So if you don't have, so I heard you have 14?
40.
40, yes. So the problem is, how do you work with this at scale? And also, to what extent you can trust the information that's there. I'm not saying that we should not trust you. I'm just saying that we have a general problem to say, well, once we use an API or something to make decisions at scale, we need to make sure that the input is actually of a really high quality. Does that answer your question?
no, it's good flavor. Okay, so the cumulative conditions of Article 17.4. They can be seen in two ways. So in one way, they are cumulative conditions which enable you to avoid liability. And the other way to see them is as a formalization of a takedown system which focuses on the nature of information. And you can read them both ways, I think. I mean, you can focus on relevant and necessary information and substantiated notices, or you can focus on the filtering end. Ensure the unavailability, disable access, prevent future uploads. Okay, so there are basically two directions through which you can read, what is offered there as an avoidance of liability. So I pose a challenge really. So if you are a platform and you want to avoid liability, and I assume what we heard from SiteGround is probably the closest. So you are unsure whether you are liable or not. But if you are a platform and you think you are within Article 17, and you want to avoid paying, what is the route? What is the route to avoiding paying money? Is there a clear route through here?
No, in my opinion, there is no clear route, but at least we can try with, as I said, filtering, and with more strict procedures, and we can employ more people to work on this, because otherwise you cannot be sure.
So I think that there is a clear route. I mean, as clear as a code of conduct and voluntary measures can be, because the route is exactly the one that's defined in Article 17.10. The route is to go back to a multi-stakeholder discussion, come up with all the standards of the requirement, and then having them endorsed by the Commission, which is going to issue a guidance. So probably we're going to have guidelines, which is going to be extracted by that multi-stakeholder discussion. So this is the route.
Any other interventions on that point? Yeah.
So I guess the way I understand Martin's question is something that I've also been asking myself is essentially, I'm a platform and I don't want certain type of content to be on my platform, but because it's user generated, it's not editorial decision that I make, so it's someone else's decision. Now, how can I structure my service to prevent that users upload something that I don't want to even have, because I don't want to conclude licensing on that particular content, because I don't want to even carry that. But it's not my decision because it's user generated. And the question is, how can you do that? Essentially, how can you exit some works given that it's not you who actually put those works on the platform? And that's, I think, the question, at least, is also what Martin is asking, and I keep wondering. I don't know what the answer is. Whether the answer is preventive measures that satisfy, obviously, this particular provision, but then you have best efforts. Now, does that mean that you have an obligation to license everything that could be uploaded to you, or you still have a choice to say, I don't just want some type of content at all on my platform? You can, of course, say it in your terms of use, but you need to communicate it also technically. And I wonder how that's going to work.
So there's a sort of answer already for porn. Because if you go to YouTube, you won't find porn. Well, you may find it, but you won't find it. Thing is, technologies allow to prevent that content from being uploaded, because porn is a form of content that you can have machines detect based on their understanding of the images. In other words, you know it when you see it. Okay, there's no need to know the legal status, whether there's a work inside or not. It's just, you see flesh, you see a penis, yes, you can block it. Okay, the machine vision understands that. Now, for I mean, a design on a T-shirt, you know, this is something that we don't know whether it's public domain or not, etc. So this is the challenge to the technology. And I think here it all depends on whether we can build technologies that understand the copyright status of something. So I would say that some forms of answer exist for forms of content that you can understand through computer vision. But otherwise, the question remains open.
Well, I have a question to providers because we all know that we don't find sexual images on video sharing platforms. We don't find images of crimes on video sharing platforms. So to some extent, there exist already some filtering systems. So why do not apply those systems to other kind of content? So what are the limits to that?
But they're obviously not based on substantive notices. There are obviously systems in place already. You know, filtering is happening now, okay? But it's not based on a formal system. And so one way of looking at the conditions is that they will lift the lid. So because of the insistence that the information has to be supplied in a particular form, we may for the first time be able to understand what filtering is actually taking place. So at the moment, there's obviously no requirement that you know, it's only if you want to avoid liability, you know, you have to conform with standards of information under which you you know, instigate the process. So we don't quite know how this will turn out. You know, will the member states prescribe a sharing of information, a public database of rights, which is independent of avoiding the liability? And can they do that? And, you know, can they just start an administrative law of this kind?
Yes, but the direction in which you're going, I'm a little bit confused because I think we don't need the member states doing anything. We're just going to need to wait from 6 June 2019, the Commission starting the multi-stakeholder. So it's going to be done completely on a voluntary basis. And it's there, it's in the provision. I mean, exactly this multi-stakeholder dialogue, which then is going to be crystallized by Commission guidances, it's just going to fix all these problems. It's just going to say what, I mean, I know. We'll see. So we don't even have to be too much troubled by which standards are out there. It's so fragmented. There are millions of them. No, because it's going to be to Article 1710 that we're going. I'm really looking forward to see what's going to happen through this multi-stakeholder. My worry is that the standard they are going to go to down to the minimum. So we're going to have a much more over-enforcement there. But I think that this is that 1710 is the answer to the question here.
Okay.
Just very quickly on this, I think there is not one size fits all solution, obviously. So you won't have like one answer for that kind of stuff. So I think it's a combination of different measures indeed. And you mentioned it, but there is some programs already existing. I have the example of eBay and their Vero program for Chinese counterfeiting goods. It's actually, well, I don't know in detail because I'm not a technician, obviously, but it is mixing different kind of solution, which is education. So they are making clear for their user what they are entitled to sell on their, so it's an e-commerce platform, obviously, what they sell on their platform, what they're not able to sell, and there are, if you want to call that way, small filters into place for other type of IP content. I don't know if it's a solution, but I think, and then also I wanted to say that the other part of the solution is, as Giancarlo said, the collaborative way. And on our side, for STM publishers, but I'm sure it's true for a lot of stakeholders, negotiation on a voluntary basis for tackling this kind of issue took place already since 20 years, probably even more. So yeah, in a nutshell, I think it's a combination of different measures. Yeah.
Okay, questions from the audience. So
Yeah, sure.
Mikael can go for it. You give one response,
just-
and then we go. Yeah.
Very briefly, so you were mentioning which is the way out and on the route to escape. Well, those are actually three different requirements. So it's not just the filtering or the recognition technology to stop this content which has been already informed by providers, but also these best efforts to obtain an authorization. And so you may, it is difficult. I'm not in a position of the platform to say that, but I guess that's difficult for a platform to be in the safe side and to be certain that it has made all the efforts to obtain an authorization, which is a cumulative requirement, as was discussed before, and I'm completely agree with Joao in this sense that if you are not able to demonstrate that you have made these efforts, you are liable, and because this is what explicitly states Article 17.4. So maybe there are fields where it is difficult for you to be sure that you are in the safe side, and you may want to avoid some types of content that may not be easily licensed. I think not just of music and video, but especially on other kinds of copyright content, even recitation, even well, photographs and so on. And I think one of the key questions is not just whether or not you are liable in face of the directive, but whether there is a risk of litigation there. So, and I would like to hear also from right holders whether is it their intention or is this foreseeable seeking damages from platforms without having provided a specific notice of the presence of this element on the platform, or else having provided a general repertoire reference files to put up this recognition system. So in the first place, so in that case, the platform could be in a safe side. So if I have, whether or not I have methods to obtain an authorization, I'm blocking everything I have been informed, and I'm keeping down everything I have taken down, because the same file may serve as a reference file. And then should I worry about the authorization? Well, if the only risk I foresee is that I am noticed about this content, and then I agree to keep it down, that would be a different situation. But in the face of the directive, that's not, I don't see whether this could be a sufficient or a situation where the platforms can rely on. But
Okay, so we're taking some questions from the floor. So there are lots of them. So I start, in the front.
Thank you. My name is Dirk Voorhoff. I'm from the Human Rights Center of Ghent University, and I would like to comment, make some observation on what Alessandro said about the specific obligation by referring to the opinion of the Advocate General in the Austrian Facebook case. Because I think we are talking about two different kinds of specific filtering or specific monitoring. The case of Facebook is that there is a specific duty to filter after there has been a court decision that the content is defamatory. So I think this is a quite different situation than the general specific monitoring obligation, what is referred to in Article 17. We don't have a court decision after a fair trial with all principles of due course, where it has been decided that some content is illegal, in that case defamatory. Here we are for a quite other situation where the platform itself, on the basis of the information of the right holders, need to assume that it might be illegal, but it might be legal too. So I think this needs to be put under attention, that you couldn't say that it is already in the line of the case law of the Court of Justice. First of all, it's only an opinion by the Advocate General at the moment, but it is quite something different, the obligations under Article 17, than what we have seen until now, popping up in terms of specific obligations after a court decision that something is illegal. That is what I wanted to make clear.
Hello, my name is Schmiemann. I'm from the Dutch Perm Rep. I have a question to the gentleman, which is to me most on the right. If I understood you correctly, you said the Commission's guidelines and stakeholder dialogues will solve a lot. As I've been involved in the negotiations for 3 years, we had many of the questions we've heard today. We didn't still see any solutions. I think part of the reason for this initiative was that stakeholders couldn't agree in the first place. The second thing is actually that I asked myself what will be actually in the guidance of the Commission. It's not binding, so we will still end up with 28 different systems. So
I have no hope in the fact that the stakeholders are going to fix it.
That's the same for us. So
I
the
have no
question
hope that on the fact that multi-stakeholder dialogue is going to fix everything. But this is what it's in the law. So this is what the law decided that is going to happen. So maybe the policymaker didn't think that true, but that's the law. That's what they expect that it's going to happen. It's the law. It's Article 1710 that these multi-stakeholder dialogue are going to fix everything. So that's why I'm saying, because that's the law, we have a route, we have a solution because it's in the law.
So it's good to see that you're still realistic after this.
I gave it to yours.
Yeah, I had again also a remark about Article 1710, because it seems to me what's so interesting is that these things are really connected. You know, the performance of the regime and what is expected from the platforms to do is connected to liability in individual cases. Now that creates a lot of issues. It's like I think you see in a few other areas of platform responsibility that you see an emergence of regulatory frameworks that say these are the kind of things that we expect platforms to do, and this is our regulatory oversight mechanism. And we have some sticks, like some fines, but they're not connected to doing the right thing in individual cases. You know, we're going to oversee whether you're complying with these duties of care in a more general sense, and that creates a lot more flexibility for the regime to develop. And in this situation, I think so. You make the forum for deciding then in the end. You know, courts will have to decide, and that creates like a lot of limitations for the space. Also, I think that the Commission has to decide on these kind of issues. You know, what to expect from Article 1710, I think, is very limited because of this connection to the liability.
Yeah, I share this view that in the end it's not probably the stakeholder dialogue or the guidelines, but it's the courts that will decide the individual cases, and they will go up to the CJU, and the CJU will, as it often does, even in specific cases, give very specific answers. Yeah? But on another point, I think the discussion on filtering, I think, is a little black and white still, because the filtering obligation is subject to proportionality. And you really have to look on the cases that are in front of you. For example, coming back, for example, to the German case law, which has been knowing filtering duties for more than 10 years now. Yeah, not according to direct liability, but according to injunction liability, Article 8.3 liability, Article 8.3 Copyright Directive liability, and our case law says, and I think not only because I'm German, but and because it's a kind of a national issue, but I think it's a clever approach to filtering, saying you only have to filter the obvious infringements, the clear infringements. They are subject to filtering, And in these cases, it's easy to police them, and you don't need a court decision. You don't need a court decision for YouTube to say this movie that is still in a theatrical window is a pirate copy and has to be deleted from YouTube. That's an easy one, yeah? And please don't go to court about this. It will, it consumes resources that we need for more difficult cases. So I think, why not think about, within proportionality, think about the obviousness of the infringement and filter away the obvious infringements and the non-obvious infringements. Maybe, I don't know if they really should be subject to filtering. Could be under certain circumstances, but you could also introduce other mechanisms, like trusted uploaders, for example. You have people that upload a lot, and they've never done anything wrong. So why filter them? Why? It's not necessary, and it would be proportionate. Maybe they make a mistake and they upload an infringement, but then you've still done your best efforts. Yeah, that's just an example, to do a flexible approach and not think black and white and say, this is an infringement because the exception of citation was just not met. I think that's not the right approach. It's rather, try to define categories of proportionality when filtering makes sense, and maybe where it doesn't make sense, because I think it's not possible still, with AI not being that far yet, to automatically filter out justified citations from not justified citations. So, and I wonder what you think about this such an approach to push filtering into an area where we all could live with.
I mean, don't take me wrong. Generally, I mean, I'm actually kind of very far from what this final solution endorsed by the legislation is. Like the example you made actually has been already endorsed by the Belen decision in Argentina. Argentina doesn't have a safe harbor regime. They really endorse exactly that model. They said that if it's obviously clearly infringing content, and the court defines exactly which type of obviously clearly infringing content, the typology of obvious clearly infringing content, you can take it down without a court order. In any other event, you're going to need a court order. But obviously this is not the case of the legislation that we are discussing right now. We don't need a court order under European law. There is also an issue with the Argentinian solution, asking for a court order anytime, that of scalability, because obviously with the numbers that we're dealing with, it might be hard to get the judicial redress every time. All the solutions you propose are a good solution. I don't know if then we can fit in something like that within the legal framework we have now through that Article 1710. If that's possible, I don't think that it's going to be, but it's not the direction in which our legislation is going.
So I want to complicate things a bit, because that's always useful. So with respect to general monitoring, I think, so there's a couple of things to be said. So first of all, there's a general monitoring as anchored in Article 15 ECD, and that general monitoring applies if you are a passive host, if we're talking about hosting here. German courts have applied passive hosting, safe harbors, to many services to which they then imposed these preventive duties. Yes, German courts were practicing preventive duties for a long time, but we don't know to what extent that was compatible with the European law, because BGH only says that L'Oréal is not exhaustive statement on what is general monitoring, so we actually never know, because they never asked that question. We can guess for what reason. But I want to say something else with respect to general monitoring, is that actually the general monitoring prohibition that is in the Article 17, it's not anchored in Article 15. So, which makes obvious sense because Article 17 tries to say these are active services. They're out of 14.1. So actually, you don't even need a carve out from 14. So, but the 17.8, I think, has its own prohibition of general monitoring. And now the question is that a same prohibition of general monitoring as the prohibition in Article 15? In case it's not, in case of Article 15, we always assume that there's a single metric for what is general monitoring. In Article 17.7 prohibition, maybe we will suddenly think that there is a progressive notion of what is general monitoring. That seems to be very close to what you're thinking about. And obviously, I don't have the answer, but legalistically, this is what I can tell you on the general monitoring is that standard can be very well different, and the court will not necessarily be contradicting itself. And we shouldn't exclude the option that that standard will be progressive because of the proportionality requirement that can adjust that standard for different types of services and different types of content.
Hi, I'm Christina from IFPI. For those who do not know the acronym, I represent music record labels. So we are directly affected by Article 17. Two comments I have. One of the guidance, since there was a lot of buzz around it. Guidance issued by the Commission is nothing new. We've seen that guidelines, be that in the form of communication, recommendation, best practices in the past. The fact is that these guidelines, guidances are not binding. So whatever is said, be that in the form, as I say, in the best practices, or any other form. This is a normal anchor sometimes in the EU legislation to have a reference to some sort of dialogues and guidance that should follow them. Another comment, which is a sort of overarching comment, as I said, because Article 17 and in particular 17.4 is something that we would have to live in practice, and I think it comes back a little bit to your question, how we would see that. I somehow sense there is a tendency to overcomplicate things in some ways. Copyright, I would, if I had to explain this article, let's say, to someone who is not very much familiar with the whole discussion of copyright law in general, I would say that 17.4 specifically comes back to very general copyright principles. Copyright is a permitted act. This law clarifies that certain players, actors would fall under copyright. If copyright is a permitted act, anything that is not permitted should be prevented. So there comes then the scheme that we've seen in 17.4, which is a follow-up of very complex discussions due to the fact that we are dealing with very specific players, in this case, online content sharing service providers. And that is why we ended with the scheme we have now. Meaning that the scheme, as many reference here, is a quite balanced scheme. It starts with good faith, as this is how we would see best efforts in licensing, good faith negotiations, contractual negotiations taking first place. Second, prevention, which is not a totality in itself. It's a prevention of unauthorized content based on the information that is provided by right holders. So any sort of negative connotation when we speak about filtering, which I actually find a very politically charged jargon, because we do not have this in the text of the directive. And last but not least, we have a third part in this very elaborate scheme, which is a notice part, notice and takedown, coming back already what we have in place currently, but then bringing some sort of next step, which is a stay down. Again, not in totality, we have best efforts. So really, structurally, logically, and schematically coming back, again, that here we are talking about the copyright legislation, which is amending another copyright directive, we have to go back to the source and see where we start and where we want to end up. And anything that happens in the middle, of course, has to have this objective in mind. So at the end of the day, we do not want to have unauthorized content, but there will be situations where there will be no information available, or there will be difficult to find right holders, And in our view, 17.4 addresses all of that.
Okay.
Thank you. So I just have a question for hooks up on what Jan was saying before on proportionality. So I would just like to hear your opinion on it. We know that the German government actually has proposed a procedural safeguard. I've talked with some of you about this by stating, okay, how do we prevent filtering, to use the political charge term, or general monitoring, in this particular case, not the 15 ECD one. Well, maybe we should have a procedural safeguard that is that the user, when uploading content from a third party, this is what the German statement says, can notify that it's a lawful use. And in that case, you import the mechanism from the complaint and redress mechanism, and you have a sort of a human-in-the-loop review. Now, there's problems with this, but I would say, what's the desirability of this and the feasibility of this in your view? Maybe, Miguel, you can start.
So can I just answer to what was said before? Okay. You know, good point that the guidelines are not binding, which is exactly going back to my point. It's non-binding, so it's going to be done on a voluntary basis, and so therefore you don't have any monitoring obligation. But I think there is a point that you made that I cannot agree with. I mean, the point that it's an exclusive right, so everything that's not permitted, it shouldn't happen. This is not how copyright law works. Copyright law is a copyright paradox. It's about balancing access with exclusive rights. So, and this is exactly the point. And we didn't really talk about that much about that. We talk a lot about right holders. We talk a lot about platforms today, but not enough about users, because that's exactly the point. The point is that not everything that's not permitted is not allowed by law. It cannot happen, because this way we curtail, jeopardize the user rights. So that just my clarification. No, but there's a tendency to think about that, and that's why then we enact a legislation that's going to profoundly perhaps curtail user rights, because we miss them in the discussion.
Well, we have a whole panel still to come, hopefully. Miguel.
Very briefly, I find the idea very interesting. I have doubts on its practicability, because every single uploader could just flag this as and having a human in the loop for every instance, that's clearly unscalable. So, but there's of course this concern about how not to overblock, which would be addressed in the next panel. But I wanted to point out, before Martin was saying that there was not even need for a carve out from Article 14 of the E-Commerce Directive. I don't think so, as I had explained. And as for 17.8 statement, I would read this as a kind of a political statement. So the application of this article shall not lead to any general monitoring obligation. It's just, it comes out from the political debate, in my view, and I'm not sure of whether this has, unless you almost devoid of any meaning the concept of general monitoring obligation in Article 15. This is kind of contradictory, but it can be used I guess, in transpositions and to have a flexible approach to what the best efforts should be considered. But and unless, of course, the Court of Justice finally comes up with a precise definition of general monitoring obligation, which so far has not been provided.
Okay, so I would like a final round of discussion around the standards of information, which are implied in under 17.4. And I would like to invite the panel really to take a view. Will we arrive at a European unified standard of information? Is that likely? Will it come as a result of the stakeholder dialogue? Or will we end up with national legislation? I mean, again, that will be enormous innovation if we've got statutory prescription of the procedure under which copyright infringement is taking place for platforms. I think that would be, for European law, a quite different take than before. So I would like to hear your view. How, where will we end up on the stand of information question?
If you do that through a legislative means, through the administrative law nationally based, then at that point we are going to have we might have a monitoring obligation, and therefore, and at that point though, we might going to have some sort of uncompliance with Article 15. If we don't do that, and the obligation are just going to be decided through the multi-stakeholder dialogues and going to be just taken on a voluntary basis through some guidance that then can be implemented on a voluntary basis, then there's not going to be most likely uncompliance with Article 15. This is how I tend to see this.
Just if I can. It's a really interesting idea, but I think it does not take into account sufficiently the difference in content that is across the creative sector. I mean, obviously, a scientific article is not the same as a movie, is not the same as a music a clip or a song. For us, it is easy to have fingerprints and DOI that all academics know. It's not probably the same for all type of content. And I'm not sure I answer your question, but I understand the uniform way of information as a way of encompassing all kind of content and information related to that content. And I think keeping in mind those differences in content, I don't think it is really it is something we can realize easily, if we can.
And plus, there is the 0.5 oversight of Article 17 that already provided in order to determining whether the obligation has been complied. He had to see and to check the type of content, the audience, the availability of suitable and effective means, the cost. So is the legislator who's already make some difference based on the type of content, probably, the kind of means you have to apply to that kind of content. So I don't know. I think that at the end you should check it out on a case-by-case basis.
Okay, so one or two final questions. Okay, yeah.
The point has been made actually by Martin Husowicz partly, but I think I again want to repeat that because it's coming back. The services that are covered, which was the issue of the first panel, under Article 2.6 of the directive are those who are no longer benefiting from the Article 14 of the e-commerce directive. Hence, not the 15 of the e-commerce directive, because the services that are not covered by 12, 13, or 14 cannot be subject to 15 either. So that's the logic, it's the logical consequence. And using netlog case for the general monitoring analogy, I think might not be very accurate either, because when you look at the case, the court's decision says that where the service has to find out which of the content from all of its content are illegal, would be putting on the service an unjustified obligation to find facts about each of the content and make a general monitoring. Whereas in Article 17, what is required is a targeted, specific monitoring based on the information provided to the right holder, which is totally different in substance and operation than what was required by Netlog or Scarlet, which actually gave the justification for the court's rulings. So I think these are important elements when analyzing the services that we are dealing with, and it's also actually comes to the concern of the site ground. I think, again, Martin Usowicz's comment there was important. It's much more about the services, how they are structuring themselves. That if you're structuring yourself as a service whose main purpose is giving access to copyright protected content for profit-making nature, then you will be covered by this because it's leading to communication to the public without safe harbor regime. If you are not structuring your service in that way, that you are going to continue to be subject to, if it happens, Article 3, as it is with full liability or the safe harbor regime. But what I think is that there's a lot of taste and a lot of interest in having this kind of services. This is the reason why they are so popular, and then they're growing all the time. And then this law is trying to address this issue in a constructive manner. The aim of the law is not to create something by which no one wants to be bound with. It's much more actually a provision that if you are doing this kind of business as described in the Article 2.6, you are better covered by Article 17 than you are not, because you have certain guarantees as well, and then you are also providing guarantees for the consumers and users too. I think it serves to the society's need to use this kind of services, but also society's need that those services are responsible.
Thank you. Okay, so any final thoughts from the panel? Then we conclude. Are you? You think everything has been said? Yeah. Yeah, okay. Yeah. You feel free to conclude. Yeah.
No, I just have a question in case you don't have. I have a question on what transparency shall we impose when it comes to these measures. To whom and what information should be disclosed on what kind of preventive steps are being taken? Only to the right holders, also to the users, describing how technology works, what steps we're taking, what different procedures are internally implemented. What exactly should we, in terms of transparency, expect from platforms, or should we even prescribe audits? I don't know. What do you think with respect to transparency?
My point here, I'm going to restate what I was saying before. I think that transparency is going to be a big issue, because it's not only transparency, but it's the transparency of the algorithms. That's the key thing here. And I think that we're not going to get anything good coming out of these multi-stakeholder dialogues, because companies are not going to be willing to share or to come up with any voluntary obligation on being transparent of that. But that's the key issue of all this. I don't have the answer. That maybe the company is going to have more practical answer. But I think from a technical application of the framework we have here, the framework is really badly shaped in order to assure us, to guarantee us not transparency of the how the process is going to work, but transparency of the underlying technology, because that's the most important thing. And also, I think that the systems, any type of multi-stakeholder dialogue, is completely unfit for that, because right now, at this very moment, we are still debating whether, so what is algorithmic accountability and transparency? It is just, we don't even know to whom should the algorithm be accountable and for what it should be accountable. So I'm very, very worrisome about the direction in which we're going here.
It's actually interesting that it turns up under 1710, isn't it? That's the only place within the stakeholder dialogue, users shall have access to adequate information from online content sharing service providers on the functioning of their practices. But that's it's only during the stakeholder, that's where information can be obtained, which is not really confidence-inducing for the mechanism which comes later, Maya.
I wanted just to say that there should be transparency for both users and right holders. And at the beginning, when I start explaining for the company, I said that we already implemented internal policy. So we have a special acceptable use policy, which is for users. So we explain them very briefly what they're allowed to upload and what they aren't. And I think this is the right methodology, and it should be like this. Yes, this is my personal opinion.
Bit the same here. I think there needs to be some level of transparency. On our part, we are already very transparent. Our publishing agreements policy are available, so authors and researchers in this specific case knows what they can share, where they can share, with whom, etc., etc. And I think it is very helpful in the debate of having illegal content uploaded generally. So this level of transparency is needed completely.
But sorry for the provocative question. Will you be willing to disclose your code and to let everybody know how?
I think the code
everything
is a trade
working?
secret.
I mean, it's not just for you the question. The question
No,
is for
I
any industry in the room.
But I think
because without that, how can we be transparent?
It's very,
Yes,
it's
exactly.
very
It's a
unlikely
trade
that we will
secret.
resolve
You
this
cannot expose
today.
the code.
I'm afraid.
Yeah.
But
Exactly.
without that, you're not going to be transparent. I know that you're going to say it's a
Yeah.
Yes.
Exactly,
Yes.
not the trade secret itself.
If I show you an algorithm, it means nothing except the technique.
Okay.
It's just instruction, technical instruction.
Okay, it's getting wild. So, and the time is up. I know you had your hand up for quite a while. Very briefly, very briefly. Then, yeah, that.
I just wanted to make quick comments from my research about the last topics that have been discussed here. I don't think we are at war here, this against the other. For my research, I think the only solution is to have a cooperation between all the sectors, the technology, the ISP, the users, and the copyright holders. And that's why, first of all, we have to bear in mind that YouTube has already gained an experience of over 10 years of developing technology of software, and I'm sure we can learn a lot from their experience, because they're, as they you can tell better than me, they have more than 95% of accuracy in filtering infringing material, which almost 100%, and that's something I'm sure new technology companies can learn from them. The other thing is, this is to address. Okay, all right. So I think we need to cooperate and make it an open source and not keep it as a secret how to filter, because this is a common interest of everybody.
Okay. Well, we are over time, I'm afraid, and we have the next coffee break. So please thank the panel.